The ethics statement. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. So if you know of a conflict of interest that you have at this time, please let us know, or if you realize it later, let us know at that time. We have a lot to discuss today. There was a lot of spirited conversation in the subcommittee, so I expect that may be the case here today as well. So we will start with our special agenda items, starting with administrative matters, report on trust account audits.
All right, and Ann could not make it today. She sends her regards, but I'm going to provide the audit report. This past quarter, she conducted audits in Durham, Guilford, Mecklenburg, Orange, and Wake counties. The most common rule violations were that 40% failed to identify the client or the source of funds, the original deposit slip, and 36% of those audited failed to review bank statements and identify the client on confirmation of the funds received or dispersed by wire, electronic transfers, and again, 36% failed to maintain images of clear checks or maintain them in the required format. This is pretty common. This is the same type of number, the same type of sort of issues that have been identified in prior audits. Based on the geographic plan for 2024, you all remember there was an overhaul of the random audit process, so it's not just this, we select a single or two counties and goes out there, but they do the random selection at the beginning of the year across the entire state. So the second quarter's audits are scheduled for Beaufort, Cherokee, Cleveland, Craven, Edgecombe, Forsyth, Franklin, Haywood, Hyde, Johnston, Macon, Mecklenburg, Nash, New Hanover, Onslow, Pittsburgh, Wake, and Watauga. Look, Anna's going to be in North Carolina. in North Carolina. So that is the audit report.
That was a great way to put that. Thank you, Brian. All right. Next, report on ethics phone calls during the prior quarter.
Last quarter, Nicole and I and Brian answered 1,272 ethics inquiries, and that is above average, especially for that quarter. And the top categories of questions: conflict, always number one; trust account, and that has a lot to do with the new import systems; confidentiality; and firm dissolutions. And we're going to look at that a little bit later in the agenda when we look at the inquiry of salvage.
All right, thank you so much. Anybody have any questions? I should have asked if you have any questions about the audits too. All right, report on CLE ethics presentations during the prior quarter.
So in the past quarter, staff provided 11 different CLE presentations. One thing that I'll know, I had the opportunity to go out to California in February to present to the National Organization of Bar Council on our rule amendments regarding confidentiality and prohibiting inappropriate pictures being sent by lawyers to clients. And I have to say, on that latter rule violation, or that new rule that we have, the reaction from these representatives from across the country was really pretty entertaining. We included some, with the assistance of the Office of Counsel, able to present some redacted examples of images that have been provided to the State Bar attached to some of these complaints to show that this is actually a real problem. But the reaction was really a kind of, we need to see this language because we've seen similar things in our jurisdiction and we may need to adopt a rule ourselves. So, again, North Carolina leading the way in prohibiting sexting. So feel good about yourself on this thing. But that's it. We do make ourselves available for CLE presentations. If you have a group, an organization, your local bar, you need an ethics hour, whether it be in person or by Zoom, just let us know because, of course, that's one of the best things that we can do as staff and as a state bar. Get out there, make sure that folks realize there are faces associated with the ethics staff. But really just kind of help folks know that the State Bar serves as a resource to all lawyers.
All right, any questions on CLE? All right, Next, we will move to our subcommittee reports, and as I stated before, we had some really spirited conversations in our subcommittees. I want to, as always, thank the staff for the work that you do in making sure that the subcommittee members are, get all the information that they need, and drafting of opinions and all of those good things. It really helps move things along. So we'll start with the inquiry of Queenie.
That's me. This is an inquiry that's been around for a year now. And there has been a lot of debate around this issue, and we haven't even published an opinion for comment yet. So anticipating that when we do that, we will have even more debate. The issue is the permissibility of including a provision in a fee agreement that will require a client's estate to pay any legal fees and expenses that arise if the law firm is required to participate in any legal proceeding pertaining to the client's estate plan after the client's death. An estate planning law firm is considering a fee provision that actually originated from the American College of Trust and Estate Counsel, ACTEC. Is that I want to say AFLEC, which is probably what I will say. The provision requires the client's estate to reimburse the law firm if a firm lawyer is deposed, called to testify, or required to respond to discovery. And the provision provides that the lawyer's time will be billed at the lawyer's future hourly rate. There was a proposed opinion presented at the April 2023 meeting. The proposed opinion concluded that the provision did not comply with Rule 1.5 because it was too vague and because it could lead to clearly excessive fees. The proposed opinion left open the possibility of allowing some type of fee provision for future fees for collateral litigation if the provision was more narrowly drafted. At that meeting, several subcommittee members expressed support for allowing this type of fee provision, particularly for estate planning lawyers, because in that practice area, future litigation is foreseeable. There was also discussion about potential problems with drafting an opinion that was limited to one practice area. The inquiry was sent to subcommittee, and it has remained in subcommittee for several quarters. We have had several subcommittee meetings. We've done a lot of information gathering. We're still working on it. During the subcommittee meetings, there's been discussions on whether this type of provision is even necessary in the estate planning arena, because there are already several statutes that address the review and reimbursement of witness fees and costs in estate proceedings. We have also obtained some information indicating that this provision was provided by ACTEC to its members about 2 years ago, and that it's already being used by some estate planning firms as well as some firms in other practice areas. Carl King, who is the ethics chair of the estate planning and fiduciary law section of the North Carolina Bar Association, has been a really great resource for us, and he has participated in 2 of the subcommittee meetings. I've got some new information from him, but I didn't know, Ashley, if you wanted to say anything else.
I think you covered it beautifully. I'll just say that this is a particularly thorny problem, and the subcommittee, I think, is really well positioned to deal with it. Martin Scott has a lot of, I don't see Martin, has a lot of, hey Martin, has a lot of experience with caveats. I also represented real estate lawyers when I was in private practice on this exact same issue. So I really do think that we've got the right folks at the table, and are bringing in Carl and others to try to advise us. I think the biggest concern that we have is drafting an opinion that would give lawyers the ability to put into a representation agreement that they could collect a fee in the future, and then how expansive that could become to other practice areas, and then also that potentially the lawyer could be involved in testifying, and then later be determined to be negligent. And so, how does that then work if you're allowing the lawyer to recover fees for the defense of his work? So those are some of the thorny issues that we're dealing with. We're not ready to present anything to the committee, and may not be ready to do that until the fall, because and Suzanne can share about that.
Yeah, I talked with Carl earlier this week, and he is a member of ACTEC. And in March, he attended the ACTEC Ethics meeting. He learned that the ACTEC Ethics Committee is forming a subcommittee of lawyers and law professors to review the provisions of ACTEC's sample engagement agreements, including the issue of compensating the drafting lawyer in event the lawyer is required to respond to a subpoena or is asked to testify in litigation. Carl told me that the full ACTEC Ethics Committee meeting is in June, and he anticipates that the subcommittee looking at the same issue that we're looking at, they're looking at other issues as well, is likely to make a report at that meeting. And Carl suggested that it might make sense to wait and see what language comes out of their meeting, and if it's language that seems to fit better within our rules, that we draft an opinion looking at that language rather than the language that we're looking at right now. So that is, I think, what I think might be the best course of action at this point.
All right, thank you both. Any other persons from the subcommittee, would you like to weigh in on this discussion?
I hope that the ACTEC subcommittee puts as much time and care into it as we have, and looks at all the complicated issues and doesn't just seek to lobby for their interests. Because I come from this on the outside of the game. I've never practiced things. There were just so many glaring concerns about how to narrowly tailor this thing. So I'm hoping to see that.
And we have come up with some language that we would, putting aside what ACTEC may come up with, the subcommittee has come up with some language that they would obviously want included. And I think one phrase was that they wanted to include was, as long as the lawyer is not a party in the proceeding. And so that kind of takes out some of the problems with the lawyer's own negligence, and also add statements that it has to comply with Rule 1.5. So, we have looked at it a lot, and we already have some terminology that we would definitely want to include, but I'm very interested to see what they come up with.
No other state has addressed it.
Any other subcommittee members want to weigh in on this? All right, do I have a motion? I think the motion is sending it back to the subcommittee.
I think it just stays there.
It's all about how you can say it, right? Or it remains. So I have a motion to remain in subcommittee.
Second.
Motion and a proper second for this issue to remain in subcommittee. Any other further discussion? All those in favor of that motion, please say aye. Aye. Any opposed? Nay. All right, that passed. So it will remain in subcommittee. All right. Moving right along, proposed 2023 FB03. This is our self-service kiosk issue. I think, Nicole, you have that one?
Yes, so you all remember, we've been talking about this one for a while, but this is the inquiry where a company wants to put a kiosk for ignition lock services in a lawyer's office, and the lawyer, of course, does criminal defense, and would want to pay, they want to ask the lawyer to have the kiosk in the office. They will pay rent to the lawyer for the kiosk, and they will pay a referral fee for every client that is referred to the kiosk, and then they will list the lawyer on the company's website as a kiosk provider. So after the October meeting, the opinion was published for comment. Let me back up. The opinion provided that the lawyer could have the kiosk in their office. They could accept the rental fee. They could accept the referral fee. It was all considered a personal conflict of interest under Rule 1.7a. However, it was a consentable conflict, so under Rule 1.7b, provided that the lawyer makes a full disclosure to their client, the client's given informed consent, confirmed in writing, then the lawyer could make referrals to their client for the kiosk. So after the October meeting in 2023, the opinion was published for comment. We received one comment from the inquiring lawyer, Mr. Reese, who pointed out that 99 FEO1 already prohibits a lawyer from accepting a referral fee from a third party. So the opinion was returned back to subcommittee. I redrafted and revised the opinion so that it was more in line with 99 FEO1. There was still the question of, is there a difference between collecting rent from a third party and a referral fee from a third party? So the subcommittee met twice. They met on February 27, 2024. And at that meeting, they discussed whether the rental fee should be treated the same as a referral fee. They pointed out, or we pointed out, that a rental fee is static and is not tied to performance, whereas a referral fee is another financial resource for the lawyer and is tied to performance. The subcommittee decided that the rental fee and the referral fee is the same type of personal financial interest that the lawyer would have in the kiosk, and that interest would interrupt the lawyer's duty of loyalty to the client, and that both the rental fee and the referral fee should be a prohibited conflict of interest, not consentable. So we revised the opinion to be more in line with the subcommittee's changes on that, and met again in April. And so at the April meeting, they approved the revisions. We did some wordsmithing. We got some helpful language from Ellen Murphy. And so we just made a little change in opinion number 1 about, and the statement now, and you can see all this in the subcommittee report as well as in the materials, but the sentence now reads, however, when the conflict is caused by a lawyer's financial interest in sustaining income from the kiosk, so that sustaining income is the additional language, the conflict is not consentable. So right now that is where the opinion is. It is a non-consentable conflict of interest for the lawyer to accept rental fees and referral fees from the company. The lawyer can have the kiosk in their office. They can refer their clients to the kiosk, provided that they have determined that it is in the client's best interest to do so. But again, they cannot accept any payment in exchange for having that kiosk in their office. The subcommittee also talked about wanting to make sure that the conflict raised in this issue, in this case, does not impede or prohibit lawyers from renting office space to other third-party professionals, such as a CPA. So a lawyer who does estate planning, for example, owns a building, has an office to rent, that they can rent it out to a CPA, and that is not going to be prohibited by this opinion.
All right. Thank you, Nicole, for that. Do we have Ken?
Yeah.
Yes. Do you want to
Sure.
give any more report on that?
I think Nicole pretty much covered it all. Obviously, we give great thanks to her. She's done a lot of work on this. We also had Brian join us in February, and as Nicole said, Mr. Reese himself was part of that Zoom call. We did actually extract input from him, talk with him. He seemed to appreciate the direction the opinion was turning, which I think all of us from last year were wanting to go in that direction. It was a matter of getting the pieces in place to kind of get rid of the ick factor, so to speak, as Evan said last time. Subcommittee members that we had on this one were fantastic. Everybody discussed it thoroughly, to the extent that once we finished the February meeting, the April meeting, I think maybe took 10, 15 minutes to just kind of agree nothing had changed. They did discuss the rent part in terms of nominal, but then you start getting into subjective issues, and as we're all attorneys, somebody's going to argue this number's nominal, but this number's not, and they're going to go all over the place. The safest way is to just say, if you're reliant on that income at all, it's just not right. Ultimately, our motion today is going to be to send it out for publication. That's the intent, but I'd like to see if anyone else wanted to speak first.
Any other subcommittee members want to speak on this? regards to the report? Thoughts in general on it? Okay. All right, we're quiet today. We're so surprised.
Up next.
You wanna make a
That would
motion,
be-
that motion?
My motion to publish for comment.
All right. Any other members of the committee wanna? Oh, I guess so?
Yes.
All right. Have a motion and a proper second. Do we have any other committee members in general that would like to comment? All right. Have a proper motion and second. All those in favor of sending this opinion off for publication, please say aye. Aye. Any opposed, say nay. All right. So this goes. Thank you to the committee. Subcommittee. All right, so before I move to the next inquiry, I do want to acknowledge Steve Robertson in the back, former counselor. Thank you for being here, sir. You have a guest with you that you would like to introduce?
I'd like to introduce Stephanie Off. Stephanie is a 3L at Elon Law.
Awesome.
2L, I'm sorry.
Good to have you both here. And I want to say good morning to our officers and other staff that are present this morning as well. Thank you for being here. All right, so we're going to move on to, now we're going to have some discussions. All right. The use of the notes function in the Odyssey e-court system. Nicole, back to you.
Okay, I'm gonna do my best and try to explain this. I'm going to have to rely on Judge Bell and Tom Langland to help me explain how this notes feature works. So we received an inquiry regarding the new Odyssey e-filing system that contains a notes feature that allows the DA to put notes, to write notes in the notes feature, and whether or not, when the judge sees that, is that an ex parte communication with the judge. So in the inquiry, you will see in the facts that a criminal defendant has been called and failed twice before, and is now up for hearing in a matter. And the DA put in the notes that the defendant had been called and failed twice before, and now we're in court on the defendant's motion to continue. And so the question is that added language of called and failed twice before outside the DA's statutory authority to set the court's calendar? And is that an ex parte communication, and will a judge act on or make a decision just based on that additional language called and failed twice before? So there are several inquiries in there that talk about that issue. We had a subcommittee meeting and invited a lot of stakeholders. So we had people from the AOC, we had DAs there, public defenders, a lawyer in private practice who does criminal work, judicial standards, and conference of DAs. So we invited all of these people to come in and give some further explanation of how this notes feature works. So, Corinne Lasik,
Corinne
Lusick, from AOC came and explained. So I'm going to read what is in her report, that is in the subcommittee report as well as in the materials, and then again, where I get this wrong, Judge and Tom, Judge, just correct. Okay,
I'm
so.
not on that subject. Tom England is.
Tom England.
I'm sorry.
Yeah,
I'm
Tom.
sorry.
He's a great.
We had Tom
That's
England from Washington, who's on grievance,
Okay,
on this subcommittee as
Okay.
well.
so I'm sorry, so Mr. Langland, you're excused. Okay. So what Ms. Lusick explained is that the DAs have limited access to case manager application, to update the calendar, reschedule continued cases, or add witness victim cases to the case party record. All of which is in compliance with their statutory obligation to set the court calendar. The DAs can also create a task to task the clerk to update information. So there's a difference between just saying notes and a notes in a task. Okay. So, the public defenders have access to case manager and can send tasks in it, but they cannot update anything in the case in case manager. So I guess there's under the notes feature of the case manager, they cannot write anything in that. The DAs and the public defenders can technically send a task to a judge, but they're not trained on how to do so. So they have the ability to send a task to a judge and write comments to the judge, but they're not trained on how to do that. The note tab in case manager can be viewed by the DAs and public defenders, but they cannot create a note in the notes tab. Lawyers who are in private practice do not have access to any of this. And it was explained at the meeting that the reason that they don't have access to the notes and the task feature in Odyssey is for security reasons. So court-issued or state-issued computers have built-in mechanisms to ward against cyber attacks and things like that. And because we don't know they don't know what every lawyer, what kind of protective measures they have on their own computers, that's why lawyers who are in private practice don't have access to this notes feature. So the subcommittee, there was a lot of discussion about how it all worked, who had access, who didn't have access, who could write, who could view, who could write and view, and whether or not there is reason for an ex parte communication to occur. The ethics committee ultimately decided that they're going to send Brian and me back to the drawing board of drafting not a formal ethics opinion. They thought that a formal ethics opinion was not the right route, but that we would draft something to provide guidance to lawyers, which means that it could change as other issues come up with the Odyssey system, and that guidance, that written guidance that we would provide to AOC and to anybody doing the training to help lawyers understand what the ethical pitfalls are in using the Odyssey system and the notes and the task feature. So I think that's my report. And I'll ask Judge Bell to provide some further explanation about this notes feature and tasks.
First off, Nicole, excellent job, excellent job. We had very spirited discussion, and it wasn't from anybody, it was very sincere concerns from the various stakeholders. Private practice lawyers were very distressed to know that there could be something in there that the judge had access to, public defenders had access to, DAs had access to, and they did not. It was explained by the representative that they could go to the court and look at the court kiosk, which would give them that access, but they did not have access from their offices. And so they were distressed about that. There was a lot of discussion, not fully appreciating, and I did not fully appreciate that there are different kinds of notes. Because I made the statement and said that when I'm on the bench in traffic court or DWI court, and the DA is going to send me a task, and some of it depends on the judge's preferences. What do I mean? I want to know what's happening in the courtroom. And so if we get ready to do a plea, the DA sends me a task, and they make some notes on that task, usually. Guilty plea, and some other information. That comes to me in a note, I can see that. It comes to me in a task, I can see that. What we do know is sometimes defendants change their minds. And they decided between talking to their attorney, talking to the DA, and getting in front of the judge, for whatever reason, I no longer want to plead guilty or I don't want to do that. What happens to those notes? Once the notes are in there on a task, they're always in there. But they are in there in different places. I didn't fully appreciate that. There also the ability for, DA England was saying, wait a minute, I got to be able to make notes to other DAs because, and I don't think you can see those notes. And so there was some, wasn't tension with us directly, but it was tension in, I think we're talking, I don't know what you're talking about. I can't make notes that the judge can see. What I didn't fully appreciate till just now, because Nicole and I were talking before we started, trying to see, I put a test note in, and then we went to notes and we couldn't see it, and I was like, that doesn't make sense. I had to go to a different screen, pull up the task screens, and then look at each individual task, and then click notes, and I got it. I can see the note. And so there was the discussion also about the fact that in different parts of the state, we do things differently. What do I mean? In Wake, if a defendant has been called and failed, we don't make them wait and come to court to deal with the call and fail. They can fill out a paper, and on that paper they can say whatever they want to say about what happened. I was sick, this happened, I overslept. That form then goes to the DA's office. DA's office gets to put a note too, and that's where they might put called and failed twice, or warrant for arrest, or all of this. And the DA's office was saying if we don't do it that way, then the defendant can have an ex parte communication with the judge by putting it, what their reason is, if it went straight to the judge, they've heard from the defendant, but they haven't heard from the state. So I personally feel a little different about that, because everybody gets their bite at the apple. The person filling out the form gets their information, the DA's office gets to put their information, and then when it comes to me, because when those things come to me, I pull it up, and I can see what the defendant wrote, what the state wrote, and make a decision. So I feel like everybody has a bite at the apple on that. But I was initially started talking about the plea. If somebody's going to plead, then we get a lot of information by consent that we wouldn't get in a trial. What they blew, which wouldn't come in until later after they jumped through some hoops and some other things. But if they're going to plead, then some of that information comes through right after they say their plea, and some of it could come through on a task, because everybody knows it's coming to the judge anyway. But if somebody changes their mind, once that note's in there, it's in there. And so have you now given, let's say for whatever reason, and I think the DAs were saying toward the end of that process that they have been cautioned not to put very much in those notes anymore. But I think there were some times when more information came through. Let's suppose somebody was going to plead and they blew a .13. And then during the course of it, which it happens, you start talking to people and I don't want to plead today. And so they don't want to plead. But that note is still there. Now they want to have a trial. I'm the kind of judge that when I'm getting ready to hear something, I'm looking at all the information I'm trying to get. Maybe I shouldn't do that to try to get good information about what's happening in the case. If they haven't even talked about probable cause for the stop, and yet you've seen the note about the .13, that could be a problem. So maybe, Judge, you don't need to look at stuff until you're sure it's going to plead. So I don't know. That's a feature. So we kind of wrestled around with that. The other piece about the call and fail, well, I already talked about that. That if you're in a smaller county, this stuff goes. This might go to the DA's office and then go directly to the judge, or it might happen all together on one day. If it's all together on one day, then maybe it's not any ex parte communication. And again, private lawyers were very distressed about the fact that they can't access this information at their post. But Nicole reminded me, well, Judge, you can't do anything about that because that's an AOC Odyssey thing, so we can't even come up with something to address that. So those were kind of the things that were present. I personally, I don't go to traffic court much, and it's a good thing. Because in Wake, there's a lot of dead time, and I like to use my time efficiently. So I stay in family court where I'm hearing cases all day long for 3 weeks out of 4. So, but when I'm in traffic court, I want to know what's happening in my courtroom, because a lot of times, and DAs and defense attorneys will talk and agree on a continuance. Well, before that used to be marked on the shuck, stuff would be marked on the shuck. Why is that important? When we get to a place, on that day is fine, but if we get to a couple of court dates down the road and somebody's wanting a continuance, either the state because their officer's not there, or the defense attorney because something happened with their defendant, how many continuances we've had and who has had them and what were the circumstances are very relevant. When there was a shuck, at least there was a physical shuck everybody could see, although the private defense bar would still have to go to the courthouse and check it out to look at it, but they still could see it. I want to know what happened in each of these notes, and because different judges preside, I make notes for judges. I say, continued over so-and-so's objection because, or witness for state was not here because he was in class, or this person wasn't subpoenaed, or defendant had a work conflict and was excused, so that the next judge, because that's important to me when I'm deciding, am I going to give the state a third continuance or defense attorney a third continuance? I want to understand the history because I think that has a lot to do with are we being fair? And so I put a lot of notes. Some of my colleagues don't put a lot of notes because I don't see any when I'm in there. And I'm not critiquing anybody. I'm just saying that's important to me. I try to put notes so they understand what I was thinking when I did whatever I did. So I think it was actually Ashley's suggestion, and I hadn't thought of it till she made it. But I think it's a great suggestion. Maybe at future, because we're not going to resolve this today because there's some language that's got to get drafted. Be able to put up, so I can show you the note I'm talking about, be able to put it up on the screen and log into the screen that I see when I first come in, log in and put a test, because I put a test for my case coordinator. Cynthia, this is a test from Bar Council, disregard. And initially, Nicole and I looked at it in notes in one place and we couldn't see it. I then I said, I don't think that's right. I went into a different section under tasks and went back to notes, and I can see it, and actually passed my screen around to Nicole so she can see it. So I wonder, and we probably need a DA here to test it and let them put a note in to see if the judges can then see that note. I think we need to play around with it with the feature, or maybe create a test. My suggestion, create a test case, but it was Ashley's ultimate idea. Create a test case, put in the system, and let different people put notes in, different stakeholders who can put notes in, and see can everybody see that. And that may help us understand how we need to give advice to everybody. So I think we had some great discussion. A lot of it I had not thought about. I was thinking, of course you want notes. Because I want to know when I see a called and failed, when I had a shuck before, I could see whether somebody had been called and failed 3 times. I don't get a shuck anymore. So when the defendant says, I came to court, but I had to leave to go to work because it was taking too long, I'm like, okay, I can kind of understand that. Or such and such happened. I was sick, or I had this happen. But if you see notes reflecting that's happened 4 times, then I'm going to have a lot less sympathy for that reason. And so I want that information, and I want to hear from both sides. What does the DA's office hear? What does the defense attorney hear? So I don't know how, I agree with Nicole, I don't think we can address the issue about private bar having access because of computer systems. We all know how, I get notes every day from AT&T's system has been hacked and your information has been compromised, or so-and-so's access has been hacked and it's been compromised. The private defense bar can see it if they come to the courthouse and look at the notes. So I understand their frustration, but under the circumstances with where we are in technology and cyber hacking, I don't know that we can do much about that. But I think we're on the right track trying to hash out what kind of notes should be put in and what should be said and what shouldn't be said. And I would love for us to set up a demonstration when we come back so that everybody can see what we're talking about.
So Ashley, you'll be happy to know that when we formed this subcommittee, that was one of the things that I asked specifically to happen in the subcommittee was for the folks from Batham, which are the AOC people who do the training for this, to actually do a simulation like that so everybody could see, because as we know, eCourts has not rolled out everywhere yet. And so a lot of people, and I trust that everybody's read the notes in the report in our materials. It's a very extensive report, which is very good, because I actually was on for some of the meeting and listened to the rest of the recording. And so this really does calculate, actually shows everything that actually happened in that meeting. But there was a lot of discussion that went on in that subcommittee meeting that everybody was talking about, and then it seemed like the light bulbs came on, like, wait a minute, I'm talking about this note section and you're talking about that note section, and there really are different note sections and the different things. So what I thought about, or just a little bit of experience that I've had so far, we're rolling out April 29th, and so we've had some training, and actually the people from AOC did train and show some of the DAs how to put notes in the task section and send it to the judge if they want. So for them to say that it wasn't, so maybe it's the different, depending on which team you get. But we decided at our courthouse that as judges, we don't want anybody sending, lawyers sending any tasks directly to us. So we have it going from the DA to the clerk and then to the judge. So we can try to eliminate some of that. But I just want to make sure that everybody understands that there are different note sections. There was a lot of discussion, like I said, that kind of went around of the actual inquiry that was originally sent in. So I would love to hear from the other subcommittee members if you are here and have some comments on this. But if we could try to keep the conversation to specifically what this inquiry is really about, because I know based on my experience thus far, there could be a whole lot of discussion about your likes or dislikes about e-courts in general and all of that good stuff. And so we don't want to go down that rabbit hole. All right, so yes, sir.
Bill Powers. I was going to start my comments very much around that it's easy to conflate an ethical issue with the respective opinions we have about honesty. I do think it's important to possibly mention that our meeting was on the 28th, and approximately a week later, which was attended by the Conference of District Attorneys. The Conference of District Attorneys actually got the News Observer. E-court's problems are serious enough to help roll out the District Attorneys say. And so it was very short after that meeting. They were legitimately concerned. They had concerns about past behaviors and things that have been done and what would happen, I guess, across the hall over there. So the other thing I took from that meeting was that not only are there notes that people can see, even amongst the e-course folks, they didn't realize that there were different portals or accessibility or methodologies to obtain the notes. And I'll hasten to add that we use a federal system where private counsel regularly logs in and there's not a security issue. Now, is that an ethical issue or is that a functionality issue? Maybe a little bit of both. But it was very, very spirited. The district attorneys were very, very concerned about that, and I thought we should, since they're not here today, express, Kim Spano showed up, and they were very necessarily concerned. I think legitimately so.
Absolutely, thank you for that. Yes, sir.
So, is there not an easy tab to see orders for arrest in Odyssey so that judges can know the history of the case?
So there's a tab that you can click on that shows the entire case file, yes. But the notes section that is being discussed in this inquiry in particular, I believe, is the task notes.
Yes.
And so that's kind of like you taking, if you imagine like a physical shuck and somebody puts a sticky note on top of the shuck and passes it over to you.
Yeah.
That's kind of like that, like please sign or have a order, kind of, how you put the little paper in the shuck and it says judge order suspending the probation or terminating probation. Can you sign this order and send it back to me? It's kind of like that, kind of telling you what the task is about and what the request of you is.
Right, and I'll add, that was one of the questions that I thought, and you kind of highlighted the issue, the tension here, where using your example, Judge, that you have the shuck where you can see the history. A judge can grab that shuck and see exactly what happened, who was on bail twice before, whatever it is. The notes within a task are like a sticky note that, say a DA or a public defender puts on there and says, motion to continue, and pointing out, call for bail twice before. The judge can see it if they look in the right place, but they're getting this extra note, and that was one of the participants said, well, why do you need to put that in there if there's this other section where you can see that? That's where it became this question of, isn't this additional communication best reserved for advocacy from the parties appearing before the judge and saying, I want to point this out, as opposed to just putting it on there so it's potentially kind of getting in front of the judge that much quicker. And I think that, one of the things I want to comment on, at the January meeting, there was concern about, whether or not this is ex parte. And I think our discussion at the subcommittee meeting really kind of didn't look at it as ex parte. We're not going down the ex parte pathway because of these questions on access. It wasn't clean to define it as one way or the other. But as you all remember, we had that opinion a couple years ago, 2019 FU04, that says even if something is not ex parte, it still may be prejudicial to the administration of justice if you are providing kind of unsolicited substantive commentary or information to a judge about a pending matter. And I think that's where it focuses on. I saw the evolution of this discussion start off with various concerns, sincere concerns. Is this going to be a restriction on how DAs are allowed to conduct their business, and how DAs do something in Wake is different than how DAs do something over in Orange or whatever it might be. And I think everyone kind of came back. Remember, I think it was Judge Trosh from Mecklenburg that kind of pointed out, what we can focus on are the fundamental principles that everyone adheres to, and that is that, like with this particular example, lawyers don't need to provide additional commentary. That's best reserved for advocacy. Save that for the courtroom. It was this funny thing when everybody was expressing their frustrations and their concerns about what this opinion might be, and then somewhere around an hour and a half in, I feel like we kind of tested for consensus, saying, do we all agree that somebody shouldn't put we'll call kind of advocacy in the notes section of these different tasks? And everybody said, yeah, you shouldn't do that. It's like, all right, well, that's what the guidance needs to be. The guidance needs to be that lawyers essentially need to think before they type, that they need to be aware of the system. And it was very obvious, like others have noted, that folks have different understanding of what the function is, what the capabilities are, where different things are. And so it's a big focus on education, not necessarily ethical restriction, but make folks aware if you put something into the notes section on a particular task, that can be viewed by a judge, it can't be viewed by private counsel, and we all understand that's problematic. So think before you type. Ask yourself, do you really need to put that? Or what you're thinking about putting, should you say that in open court in front of a judge? And I think that's where the Conference of DAs, AOC, Judicial Standards thought that would be very helpful to have some sort of kind of concise guidance from the bar that they can hand out as this educational opportunity. And that's where I see us kind of going.
I would just say the one exception I would, and I think District Attorney Freeman was making, in Wake, if you don't let both sides respond in writing to the motion to strike called and failed, then you have a individual or a individual defendant or individual defense attorney putting something on a form and it's going to the judge if you don't hear from the DA too on that. So I think that may be a exception to carve out, and they do it that way because in Wake, you would never get to file a strike call fail if you had to do it in open court. If you couldn't submit that form, the sheer volume just wouldn't let you do it. So I think that's a special situation.
I can see that being a kind of a local rules thing too, to address with different unique practices that we have.
And before we go to that, and I think you all had a discussion about that, and that was a little bit different because the information, the defendant would fill out this form, that same form would be tasked to the DA.
Yes.
The DA will put something on that form.
And so everybody's
and all of that
feedback is
information is on the form as opposed to putting it in the notes section,
Right.
which is very different.
Yeah.
Yes, sir.
First of all, I have to confess complete ignorance about Odyssey and many other things, but that's certainly it's not going to bar me from wading into this. I do think it is a ex parte situation in this. We didn't have ABO, but the opinion you're talking about, Brian, where we hammered out the ex parte communication, one of the things we stressed was the need for simultaneous communication. For instance, I could not hand deliver something to Jeff and put it in the mail to opposing counsel. That's not ethical to do that because you have to use the same method of communication. And it doesn't sound like that's possible here for the private attorneys. Yeah, they have access to the kiosk, but that's not the same as having, as having this with you and being able to see it immediately. And given the pace of district court, there may not be an ability. If I'm in Judge Bell's court and I got to be in somebody else's court in an hour, I didn't have time to run down to the kiosk, check that, and get back up there. And it just seems like that's something I don't want us to lose track of, because if there's no ability to communicate simultaneously with the court and with opposing counsel, private counsel, then I think that is an ethical violation.
And that's,
I think we have this artifact that says you have to have simultaneous communication or simultaneous method of communication.
you're absolutely right. And I think one of the things that made it difficult was, for one, there's question about whether private attorneys will have a kiosk. Because it seems a number of folks have been told there will be a kiosk, but then the representative from AOC said, no, we're not planning to put a kiosk in. So that's a question, although it seems if AOC is saying we're not doing that, then we're just not doing that. But the other thing that we heard was, the notes section on this particular task may have been, I think one of the DA representatives said, well, that's my own note. I'm putting that for myself, not realizing there's another section for the DA to put their notes that's exclusively viewable by the DA. Or maybe they're putting the note in, it's intended for the clerk, and it just is something that can be viewed by the judge. And that's where it felt kind of this, it became almost this subjective intent of what was the purpose of putting that text in there, who was it intended for. That became this question of, is it ex parte? It very well may fit the definition of ex parte, depending upon who's putting it in there, what's their purpose. But that is going to be kind of this, I guess, to me, that's going to try to catch a cloud in some ways. But I think we can all agree, if it's communication information that's best reserved for advocacy, we all know that shouldn't be in there. So that's why I was saying we kind of are not leaning away from ex parte. You are absolutely right, David. It very well may be ex parte in certain circumstances. And I think that's where some of the guidance may need to allude to that, as opposed to kind of clarify or characterizing every single entry as ex parte. So I appreciate that feedback. I think that's going to be important to tease out.
Any other comments from folks on the subcommittee?
I'm not on the committee.
Okay, go ahead.
We've got to fix the private attorney role. I know we're going to have to get AOC on board with that. I mean, I'd be furious if I was a client paid good money and I'm a second-class lawyer because he can't get access for maybe a week, right? He has to come to the courthouse and.
Or maybe not even access at all.
That's not right, bro. That's got to be.
And see, one of the questions I've always had, and I don't think it's ever been answered, as to whether or not when something new gets filed, or a comment, or a note, or whatever, anything that happens in any file that the lawyer is attached to, would they get like an automatic?
Yeah, generate an email.
Right.
To my knowledge, no.
And that's what I'm saying.
Lucy said no, there's no
There's no
alert.
notification.
Yeah, there's no notification.
I think
So at least if that happened, they would know to be.
Yeah, he's on the subcommittee, yes.
No, I think from what I've heard, the problem with that is that they would have to notify you of everything. So everything that happens on the case, whatever entry the clerk does that has really nothing to do with you or with the state, they're gonna know you're gonna get buzzed for that. And so it's all or nothing. And I think they just turned out the feature that will notify us. So we do not get notification. That is one of the difficult things about Odyssey, is that you would constantly have to go back and check. If you do tag something to the clerk to send to the judge, you got to go back and check until it is complete, because you don't get notified.
Thank you for that. Yes, ma'am.
Going towards volume of notifications, I mean, eCourts has not reached my district yet, but I do traffic and DWI law and criminal defense, and I'm just thinking on any given traffic day, our law firm is handling probably between 50 and 150 traffic tickets. On any given DWI trial day, we could have 2 or we could have 10. And it's not, I feel like every attorney would need their own public terminal to sit and look up, okay, I'm looking at this file number, this file number, this file number. Has anybody said anything wrong? Has anybody said anything inaccurate? Has anybody said anything I need to respond to? And I think we all agree that's a problem, and it's a technology, I think like Mr. Power said, maybe a functionality problem, but that doesn't change that it's just wrong. And I feel like when you talk about that in practice, I'm sweating thinking about how am I going to look at all these cases, and we're probably going to be the last county to get it. But I just think that if I have to go and see, oh, did the DA say this person got caught and failed? Then did he actually get caught and failed? And doing that for every single case, it's not realistic. I don't know. That's probably not helpful. I'm just adding more problems, but I don't know. How do you even handle that? I don't, for somebody who's in district court every day, I just don't see that as a realistic possibility.
Right. I think a lot of people agree with your statements, and like you said, Judge, that is a huge concern with especially the private defense bar not being able to see everything and have the same access as everybody else. I will say that AOC has heard this loud and clear, and hopefully they are taking all of this into consideration and moving forward and trying to make some changes. That's, I think, the best I could offer in this regard.
I would say it depends on the practice across the state. And I suspect, I don't know for sure, maybe people in smaller counties tell me I'm clueless, but I suspect in smaller counties they might not have the same volume, or maybe you tell me I'm totally wrong. And they do. And so in Wake, they needed to be able to put something in, or else you couldn't handle a call and fail by a defendant getting a new court date. That would virtually paralyze people getting a new court date if you had to only do it in open court. Because somebody would have to file something, get set on the calendar, come to the calendar, now we got everybody there, and nobody could act on it. And so the backlog on that in Wake would be astronomical. I don't know if that's the same in smaller counties, or if you can handle it differently in small. So maybe there's some guidance to be given for, depending on what's your practice in your county.
We did have a fun moment at the meeting when different counties were expressing their concerns. They noted, hey, welcome to the ethics committee of State Bar, writing something that applies to everyone. But it is one of those things. I think to me, when Nicole and I can go back to the drawing board, I expect that we'll be able to draft some sort of guidance about this to get out ahead of it. I don't know that we're going to prevent, somebody from just disregarding the guidance and the kind of advice to not put substantive stuff into these notes on a task feature. Just like some attorney may very well just disregard the general ethical requirement not to go find a judge, after court and start talking about the matter that's coming up tomorrow. We can't prevent everything, but we can provide that ethical guidance to hopefully highlight the issue, spotlight it, and give folks kind of the answer of how they should conduct themselves and get out ahead of it. But yeah, there's another component here that is purely programmatic, I guess you would say, through AOC, but I was very happy that AOC attended the meeting and they heard the legitimate concerns that I think everybody had about private counsel's inability to access any of this.
Absolutely. All right. So I have a motion for this to remain in subcommittee.
Absolutely. and let me say throw this piece out there. Maybe there is some guidance to maybe the cyber nerds can come up with, okay, private counsel, if you want to have access to the system, you've got to agree to have this much security on your, maybe, I don't know, I'm throwing that out there.
Nobody's going to raise their hand to be a cyber nerd. Do I have a second question? Yes.
On the subcommittee, is there a member of the private criminal defense bar?
Yes.
Yes.
Okay.
And then we have some chief public defenders, someone from the Council of DAs, the DA from Wake was there. There's a cross section of folks. Yes.
Yes. I speak up.
Do I have a second for this to remain in subcommittee?
Second.
All right, we have a motion and a proper second for this to remain in subcommittee. Any other discussion? All right, all those in favor of that motion, please say aye.
Aye.
Any opposed? All right, remain in subcommittee. Inquiry of Lipford.
All right, that's me.
Yep.
This is the inquiry that relates to the death of a public figure in the 1930s. The victim's spouse and a friend were charged with the murder. Lawyer A represented the friend. The charges were subsequently dismissed, but the relationship between the spouse and the friend remained the source of some speculation. After representing the defendant, Lawyer A closed his private law practice and joined a corporate legal department. Lawyer A kept the defendant's file in his possession until his death. After his death, his wife took possession of the file. Several years after the lawyer's death, the lawyer's wife gave the defendant's client to her son, who was also a lawyer, and that's Lawyer B. Lawyer B is still in possession of the file. A nonprofit organization held a public exhibit of materials concerning the case. Lawyer B believes that defendant's file is a matter of historical significance, and he would like to donate the file to the nonprofit organization. Some of the materials in the file are a matter of public record, but some of the material in the file has never been disclosed. The issue is whether Lawyer B is prohibited from turning the file over to the nonprofit based on the duty of confidentiality set out in the rules of professional conduct. At the January meeting, there was a lot of discussion about this case, and it seemed like it was pretty evenly split between committee members that felt that once Lawyer B took possession of the file, he had a professional or fiduciary duty to protect the confidential information in the file, and then other committee members felt that Lawyer B had no duty to protect the information. The matter was sent to a subcommittee for further consideration. Prior to the first subcommittee, I drafted a proposed opinion that concluded that Lawyer B could not turn over the non-public materials in the file. That draft was circulated to the members of the subcommittee prior to the meeting. At the subcommittee meeting, the members overwhelmingly disagreed with the conclusion of the drafted opinion. The subcommittee members felt that Lawyer B had no duty to protect the information in the file because Lawyer B was never in an attorney-client relationship with the defendant and was never associated with his father's law practice. The subcommittee members also expressed concern about imposing a duty of confidentiality on a lawyer in this area because it might lead to the imposition of other duties on lawyers who have never had a relationship with a client. The subcommittee members asked me to draft an opinion concluding that Lawyer B may give defendant's file to a nonprofit because there is nothing in the rules of professional conduct that prohibit it. And there is EA in your file materials. It's the one that is dated April 18th, 2024, and it goes through and sets out the facts. And the inquiry says, may Lawyer B transfer Lawyer A's legal file to the nonprofit? And the opinion is, there is nothing in the rules of professional conduct that specifically prohibits Lawyer B from turning over the legal file to a nonprofit organization. However, the Ethics Committee is concerned about the message sent to the public by a lawyer publicly disseminating a confidential client file under these circumstances. Accordingly, while not strictly prohibited, the Ethics Committee discourages Lawyer B from providing the client file to the nonprofit. So that is currently the proposed EA, which is not a published opinion. That would be sent to Mr. Lippert only.
And that came out today? Did you send that to us?
No, it's in the agenda.
Oh, it's in the agenda. Okay, thank you.
Judge Lane, do you want to
Yeah,
more report?
I chaired the subcommittee back in March, and there was consensus that this needed to be an ethical advisory, not published, not set any precedent. After all, the case is 92 years old, and the facts have been quite unique. I guess this is the third proposed opinion, the one that you drafted for us.
Well, before the first full ethics opinion, Brian and I each drafted an opinion. Both of those opinions pretty much said he could not turn over the information. We had different reasons for that, but Brian and I both felt that he should not be able to turn over that information. So before the first subcommittee meeting, I kind of took some from both of those opinions and added some more cases and sites and came up with another draft opinion that still said, no, you can't turn over the information. And the subcommittee members were like, no.
There was consensus among us. President Brown had some serious reservations about blessing this kind of conduct, given how important confidentiality is to our profession. Ms. Pearsall, who I don't think is here, is she? There you are. Hey, good morning. I thought gave me a lot of pause when she said we might infer that lawyer A, the original attorney, may have committed a rule violation, and now lawyer B is perpetuating it. So even though he was not in a confidential lawyer-attorney-client relationship with this person back in the 1930s, obviously something here, some files were not kept, confidentiality had been breached to his mother. It was a rule violation. Now we have another lawyer perpetuating that. So that gave me a lot to think about, and I think this opinion dated today hopefully addresses that concern. I know if I were an attorney who made this inquiry and got something from the law that disapproved of me turning this over, I probably would have known. Of course, he's almost 90 years old, and he may not care. But I still hold fast that there's just nothing in the rules that specifically prohibits it. I can't read the rule any differently. I think this is a good third way. This is where we need to go. We'll set a matter of precedent after 92 years.
I have a question about and I addressed it, I called for an email to address it. Was it actually a rule 90 years ago? And if not, then his dad didn't break the rules. And so does that add anything to the discussion? I don't know when the rule that we're now going under was actually set.
It could be different, but we're not saying that he broke the rules. I think that would be.
Oh, but it's been said time and time again, sort of alluding to the fact that it is perpetuating a rule violation. But if that wasn't a violation 90 years ago, then the current lawyer is not.
I think initially, though, the inquiry was not about whether the initial lawyer broke a rule, but more so, I'm a lawyer, I have the file now, do I have a duty to keep that confidentiality, right? Just on that alone, I think about it more into.
Yeah, and I just on that note, the state bar wasn't created until 1933, so I don't know exactly. The model rules of professional conduct have been around for a long time, and I think there's always been a duty of confidentiality associated with our profession. And so, whether, I guess I don't know the historic specificity of what the rule was or what the enforcement mechanism was, say in the early 1900s. But I think it's fair to say that the duty of confidentiality has been around for a long time. Whether you committed a rule violation, well, and even let me kind of jump off that because I did contact Carmen Mann, our new chief counsel, and said, here's some facts. If you heard that this lawyer provided this file to the Historical Society, would you all open a grievance file? Would you pursue discipline? And her response, it's not one of those things that we don't want to talk about, with incredible specificity of like what could happen. But she opined that this type of conduct is something that, there might not be a specific rule. It's hard to say that this is like the closest thing would be 8.4a, which is that a lawyer cannot essentially assist another person in violating the rules, or one of the points, and that's too attenuated here. But would it generate from the grievance committee a letter of caution saying, hey, this is it's not a rule violation, but it's unprofessional to give a client file to a public source, even if it wasn't yours. Maybe, I don't know. Maybe the grievance committee would, maybe they wouldn't. But it was still. I guess that's that question of, kind of what is the principle that we're hitting on here. It seems like the ethics advisory opinion says I can't find something in the rules that says you cannot do this. But I guess the notion that I would submit here is if any of you happen to have a client file on you right now, maybe you're doing work in between meetings, and you just walk out of the room and I happen upon it, would it be okay if I just took that client file, went over to WRAL and said, you might find something cool here? I don't think anybody would. But it seems to be abandoned. I just found it. I guess my point being that I don't think anybody would be happy with me doing that. And maybe that's the principle that we're really addressing.
I don't know that anybody on the committee in our discussion would say they felt like great that, that's why the sentence in that, this most recent proposed response is, that the ethics committee would discourage that. I think everybody kind of agreed about that, but I think what it came down to is if the specific inquiry is, does that conduct, a lawyer B, right, who's now the third hands that these files have landed in, who happens to be an attorney, does that conduct in releasing it violate the rule of confidentiality? And for me, and this is what I expressed at the meeting, it all arises out of where does the duty of confidentiality arise? The duty of confidentiality arises out of the attorney-client relationship. And while I agree, I don't think it feels good, I discourage it, but are we going to impose a duty of confidentiality on attorneys on anybody else's client information, right? To me, that is really broadening where the duty of confidentiality comes from and what is its inception. It's a duty between a client and their attorney that represents them, and that wasn't the facts of this. And so to me, it was a very narrow analysis just in terms of whether or not releasing that file would violate the duty of confidentiality.
And it's important to note, too, that the chain was broken. Lawyer B's mother was apparently not an attorney, so this has been outside of his relationship, even the lawyer B relationship, which I don't find. But I think that's important. So the chain's been broken.
Well, and I think we also had a discussion at one point, would that answer be different if the father had, the son had taken over the father's practice? That is a completely different situation. Yeah, absolutely, there's a duty that applies then, but that wasn't the specific facts of this case.
Or if lawyer B was entrusted with this file either by his mother or by his father because he was in fact a lawyer. You need to guard this. I know you're an attorney. Now to change the analysis.
Yes, sir.
This one troubles me greatly, I've just got to admit it. We're asked to kind of fill in a vacuum, and that's always a difficult thing to do. Back when I was much younger, there was another Professor Murphy in my life at the University of North Carolina who taught common law. He introduced us to this case, I think it's from 1892, called the Holy Trinity Church case, which says basically there is a set of circumstances under which an act can be permitted and is within the letter of the law, but it's not within the spirit of the law. And I think that's kind of where we are here, quite frankly. There's a policy reason for what it is that we're all talking about, and that is we want to promote open, full, and frank disclosure and communication between attorneys and the different client. And clearly that happened based upon the facts here. We've got handwritten and typed notes from observations and interviews, and it can have a chilling impact if all of a sudden that can be shared with the Winston-Salem Journal, with this historical society, or whoever. And that bothers me to no end. I'll just be frank and honest about it. I think it kind of abrogates the policy, and there's no question, I don't think anybody would disagree that if lawyer A, the original attorney, was still alive, and the client, defendant, under the fact pattern here, if they were still around, there'd be no turning this file over. So at any rate, I think that we've got to be careful. I think we've got to set the bar high for ourselves when we are filling in that.
Yes, sir.
After wrestling with 1.6 and 1.9 for 2 years, I do think that this is very close to a rule violation. I think the scope of 1.6 is unlimited. I mean, the duty of confidentiality prohibits lawyers from disclosing from any information, from any source. And so we adjusted Rule 1.9 in that subcommittee that got passed. But this is a situation where I think the file has been handed down to successor lawyers, and the lawyers are under an obligation to follow the rules of professional conduct. And I like the Ethics Advisory number 2 that basically prohibits the disclosure because you can't, the client can no longer give informed consent. And informed consent, along with confidentiality, are really two of the bedrock principles, as Craig has said, not only of the letter, but also the spirit of the law here. And so I am troubled if this information is allowed to be released. I know I mentioned to Craig that I've got some clients that got some really horrible secrets that, never been public. And if by some misplacement or other trouble, those files end up outside the scope of the rules of professional conduct, it's going to be really embarrassing for clients both alive and dead. And so there's no way that we can examine the file in a way that can determine whether this information is detrimental or embarrassing. We just don't know. And the successor lawyer has no way to confirm, verify, or substantiate the fact that these are not embarrassing or detrimental. And so I feel strongly that this should not be allowed to be released under the rules as we have it, under 1.6 and even 1.9.
Can I ask you a question? So do you think the entire file should not be released or just the non-public portion of the file?
Well, that's a good question, because 1.9 does, allow public, and generally known information to be released. So that certainly, as long as it's not detrimental or embarrassing. And so that's the hitch right there, that even though it may be public information that's in the file, we don't know if it's detrimental or embarrassing without some kind of informed consent, I think. I mean, maybe a lawyer can go look at it and say, well, this is already out there. But I can live with the fact that if it's in the public domain, it's certainly under Rule 1.9 can be released. But the rest of it, I think, has to stay confidential, to stay within the letter and the spirit of the rules.
Now, Evan's analysis hinges on whether lawyer B is a successor lawyer, or is he standing as a...
Well, I don't...
I think
whether lawyer B is a
just
lawyer...
by virtue of being a lawyer.
Yeah.
Whether lawyer B is a lawyer, period.
Right, not
Not necessarily a successor lawyer. As a lawyer, he is subject to the rules of professional conduct, and it doesn't matter whether he's a successor or even if he bought it in a storage unit and found a file from another lawyer and he came in possession or she came in possession of that file, that lawyer is still subject to the rules of professional responsibility, and I think it's prohibited from revealing or disclosing under 1.6.
So can I ask a question about the inadvertent disclosure during litigation? That's something I've wrestled with here, that if opposing counsel, I guess I'll just frame it. I remember a high-profile case about a year or two ago where counsel released a whole cell phone's worth of information, and accidentally, but released confidential information. And the opposing side was able to use that. And I don't think there was any ethical consideration that, well, lawyer on the other side now has information that's really critical to their case, and they would like to use in crossing one of the parties.
Well, Warren's still dealing with that.
Right. But I guess I'm asking, is that if we said that lawyer B had a duty to keep this confidential by virtue of him being a lawyer and coming into possession of confidential or information that was supposed to be confidential, would that strip the ability of a lawyer who does receive that inadvertent communication and or maybe information that their opposing counsel either accidentally, intentionally, whatever it was, but they violated their duty of confidentiality, and opposing counsel now has to say, I have this, it's for the best interest of my client that I use it, but now I'm not allowed to use it because the state bar has said that I have a duty of confidentiality to the information based on it being confidential, not necessarily because this is my client.
Brian, I see a distinction between litigation and information that's disclosed in litigation versus information that is disclosed outside of litigation. And I understand that if a lawyer makes a mistake or makes an inadvertent disclosure, that's on the lawyer and the client. But outside of litigation, I think that's a distinction that's worthy of consideration.
Hold on 1 second, Warren was waiting patiently.
So strongly as Evan feels, I feel as strongly that we're stretching the rules beyond recognition to find that there's a duty of confidentiality here. And I'll add 3 facts to this scenario that might put that into start. It's not 90 years later, it's 20 years later. The lawyer B here who comes in possession of this is a lawyer who recognizes that as soon as he gets this, that 3, there's somebody sitting in prison who shouldn't be there. Are we saying that lawyer should not be able to take what he just found, whether it be through going to a storage bin or whether he got it from his mom, however he got it, that he should not be able to go and do whatever the hell he wants to try to get somebody who's sitting in prison who shouldn't be there. He has no duty to that, to do that. He has no duty of confidentiality to the client. It's not this general duty of confidentiality to keep everything confidential from everybody. It's to a client of his that he never had this client. He didn't come by this file through any, somebody accidentally sent it to him. He didn't come by any other way than the guy who died. His father didn't cremate himself with his file. So, I mean, it's just, to me, I think that I like the rule, the one that we have before us here, that was just to say, not take this case that is so unique and trying to say something that is imposing a duty that I don't think any of us are prepared to accept just willy-nilly that now all of a sudden, to me it is, I like the idea that you just said, we're going to address this, it feels icky. Thank you very much.
David was next.
Yeah, that's a better hypothetical. I had 2 hypotheticals. One, that was one other. Mama, instead of giving the father, gives it to the Big Innocence Project. And it's a current, it's a current situation. And they were saying that the lawyers of the Big Innocence Project can't use it because it's confidential. And that's an absurd hypothetical, I think. I think we find a way to make that happen. But let's say Mama gives it to 15 years ago, 20 years ago, gives it to UNC as an inclusion in the historical record up there. Last time at that point, there was a lawyer who's been given the Macmillan Public Service Award. He was the president of the university. And so we would be saying that Tom Ross had to protect confidentiality, even though this woman had given the documents to UNC. And if he didn't, he has constructive knowledge that the library has received it. If he doesn't, then he's committed he's broken the rules. I mean, there are there are lots of horrible fact patterns, just like this one, that you can spin out there if you impose this duty. I also have a little trouble with Evans. It's okay to do this through litigation, but, you know, we generally don't try to have carve-outs for one particular area that says it's okay to do this and not others. I think I agree with Craig, it's sticky, and it does seem to violate the spirit of the law, but there's no rule. It's a little like your topic with the California bar. There was no rule that said you couldn't tell your client if she gives you naked pictures of herself, she gets a 15% discount. That's what happened here 5 years ago, and so we fixed that. And if you want to fix this, we can fix that. Yeah. So right now, you're going to talk to you.
I'll have to catch Eddie up on that.
Thanks, Mark.
Yes.
Yeah, well, to Warren's point, we amended the rules of professional conduct. I want to say 5 or 6 years ago, maybe longer, that required lawyers when they come into possession or knowledge of evidence of innocence or wrongful conviction. Not only the prosecutors, but we have an extra rule that puts that obligation on every lawyer under every circumstance to disclose that information. So that's in there. Well, extrapolate to. Okay.
Yes, ma'am.
I think too, we can, to David's point about distinguishing litigation from other, I think we can, I mean, Brian, your point about the famous case and the use of it, right, and with the cell phone records, Texas had no 4.4. Like Texas, when that happened in Texas, they don't even have a rule, not a 4.4 like we have that says if there's an inadvertent disclosure, you have to tell the other side. So we do have that, right? So that does provide us protection that they didn't have in there, that they didn't have in that case.
Right. And I think even if that happened here, there's nothing in our rules that would prohibit that lawyer from using.
No, they just have to.
Yeah, they just have to tell.
Our code specifically says that.
Right.
That's a legal issue, not government.
Yeah.
Right.
Yes. Could I have a motion in this regard? What that motion is, right?
I hope the committee adopt the ethics advisory as drafted by Brian Oaken, dated today, April 18, 2023.
Yeah, it's more to approve it, yeah.
Approve the
To
ethics
approve the ethics
advisory.
advisory, yeah.
I have a motion and a second to approve the ethics advisory.
I've got one question. Ron McCarty, that has absolutely no precedential value.
That's correct. That's correct. Our ethics advisory opinions are effectively our email responses, informal, put on the State Bar letterhead. So somebody has something that, and it has to also be blessed by the ethics committee. So that's kind of the extra layer of, I guess, credibility.
All right, so we have a motion and a second. Any other discussion? Yes.
I just wanted to point out that the header on page 2 says January 8th.
I saw that and I've already fixed it, yes.
What was the matter?
The header on page 2 says January 18th and not April 18th. I've changed that.
That's what it is. Yes.
Thank you.
All right, any other discussion? All those in favor of the motion on the table to approve the ethics advisory letter that will go out, please say aye. Aye. Any opposed, say nay. All right.
We could, yeah, we can do this and then
You abstain. So, if you all could just, I would like to forge through this, proposed opinion that received comments nor publication of proposed 2024 SBO 1 and then go have a short break and then go to our new inquiry, so if we could just handle this one, and then we'll take a break, okay? So proposed 2024 FB01, the use of AI in the law practice.
Right, and I'll keep this nice and quick. We had received a couple of comments on this opinion. Of course, you remember this is the opinion addressing a lawyer's use of artificial intelligence. It doesn't get terribly specific. It's one of those kind of higher view type of opinions that really likens the use of AI to a variety of other resources, software, etc. And just draws the conclusion that lawyers, yes, you can use artificial intelligence in your practice, but if you're going to use it, you need to be competent in your use. You need to make sure your use is secure and protects client confidentiality, and that you are essentially taking ownership of the work product, supervising, so to speak, although we're not calling it a non-lawyer assistant, to be clear. But ultimately, we published this. We did receive 2 comments. They are in your materials. One of the comments concerns the language about an administrative fee. It's inquiry, inquiry, I believe it's number, right in front of you, inquiry number 6. And just kind of the ability to charge an administrative fee for the use of AI, incorporating that into practice. And I think there's something that's worth considering there. I'd like to send that back to subcommittee to discuss that particular inquiry and see what sort of tweaks, if any, we need to make. There was another comment that was received from a group of law professors, both at Central and Duke, that wanted to encourage the committee to include some additional language that encourages the use of AI to bridge the access to justice gap. Again, I want to send this back to subcommittee to take a look at these different comments and see what sort of tweaks, if anything, to the opinion need to be made. I will say I was happy to see that we didn't have some sort of backlash of, the conclusions drawn are just horrible here. I've received some kind of informal feedback that people appreciated the opinion and they thought that it was clear in kind of empowering lawyers to use artificial intelligence, but just to be responsible when using it. So.
All right, Warren.
Yes, I agree. Let's send it back to subcommittee, mainly on the administrative fee thing. I don't want to change anything else, and I think that'll be a quick, easy fix. It'll probably take a very short meeting. I'm not sure I'm ready for us to be a cheerleader for things as far as AI's use in the future when we don't even know how it's being used right now. If it turns out to be a force for evil, I would hate to have an ethics opinion out there saying how we encourage lawyers and everybody to use it to do things. So I like the kind of neutral way we've looked at it and allowed everybody to make their own decisions about using it. And so I encourage us to send back to the subcommittee, and other than that, anybody else on that subcommittee all covered, I'll make a motion.
So before coming your way, subcommittee? Yes.
Kevin Williams and I presented on this opinion at the end of court in Winston-Salem, and we received the same administrative fee comments. And I encouraged the individual who made it to send it in, which they didn't, but I will share it here. But they're very similar to the Wharton Black comment that we got.
Anybody else from the subcommittee?
I'm not on the subcommittee, but I can tell you the thing is morphing at the speed of light, and I don't get to tell anybody anything you didn't already know, but there are probably 2 now very popular programs that lawyers are accessing. One is called Copilot, the other one is called CoCounsel. We're actually piloting both of those in my firm right now, but one is a Thomson Reuters product that's soon to become tucked up under Westlaw, and the other one is a Word document or a Word program that's going to be available on all of the EMS Microsoft platforms. So again, it's changing really at speed. We just need to kind of probably continue to monitor that in our subcommittee.
Mike.
I think Wade.
I was just going to move that we send it back to subcommittee.
I have a question.
Yes.
Brian or whoever, what is it that the law professors are asking State Bar to do?
and their letter. I didn't quite understand.
I think
The
I
request.
understood the request to be that there's that basically artificial intelligence in terms of its use and the ability to potentially increase efficiencies, that they would like language that encourages, kind of recognizes the ability of artificial intelligence to maybe allow for innovation in a practice that allows a lawyer to serve more clients and bridge the access to justice gap, whether it's serving more clients, reducing costs, et cetera. And that basically, the opinion, while it kind of gives the kind of green light to lawyers to say, yeah, you can use artificial intelligence, I understood their request to be that they want the opinion to also say, not only can you use it, but we encourage lawyers to use it to bridge the access to justice gap by the increased efficiencies that can be found in artificial intelligence. So kind of more of a strong encouragement for lawyers to explore ways to contribute to some sort of solution to the access to justice issue that the state faces. So that's my understanding of their letter.
Frank, that was my understanding too, and that's where my reservation comes in, just that we don't know what it does. Right now, I know that I used the Thompson Reuters thing. I was telling Brian this yesterday for an esoteric civil procedure question that's always been nagging me. So that's I lose sleep about it, trying to blow the future. I asked it, and it did not hallucinate cases, but it misread what the cases said, even though they took direct quotes out of it to tell me what they said, and then you go and read those direct quotes, and they didn't put it in the context with which the court was considering that direct quote. And it relied upon that direct quote to conclude that opinion said something the exact opposite of what it was saying, which was very, very discouraging on the first try. Now, it was a very esoteric question, so maybe it's just not.
So I think it's the
You're
advanced,
smart.
sounds like the advanced, the advanced AI is what we're having an issue with, because everybody uses AI.
Everybody uses
Because
Westlaw.
if you use Grammarly, that's a lower form of AI. So somebody over here, Elizabeth,
And Ellen.
and then we'll come back around.
I had to go back to subcommittee. I just wanted to surface and maybe ask, because the AI is baked in now, particularly the stupider kind, the machine learning kind, it's in Lexis, it's in Westlaw, it's in document management systems trying to help you decide which email goes where in your book. I'm not sure it's going to be possible to put it in an administrative fee or particularly going forward. It's just overhead now that I think is baked into people's rates at some point. So I'm glad the opinion took a really broad view of what it is for talking about most of our obligations. It maybe complicates it for the billing half, and maybe if we can make some distinctions, that would be which kind do we mean when we give the billing.
So notify Elizabeth when we're meeting.
If I can be helpful.
That's great feedback, thank you.
Yes.
I just want to say, I think that I'm appreciative of the law professor's letter, and I wonder if that is better placed. I appreciate Warren's concerns, but even regardless of like how we feel about AI that is doing weird things right now, if a better place to put that is have someone, a third party, write it for the bar journal.
Yes.
Like I know Ashley's group is doing some amazing things with AI and access to justice, and so like instead of it being the bar saying, the state bar encourages the use of it for a certain purpose.
One other dynamic I just thought I'd mention is that we have guidelines that we receive from clients, and you may have that as well. And what we're starting to see in terms of trends is you need to get pre-approval from the client before you use AI. And then when you tender a specific work product, you've got to disclose whether AI was used in that generation of that work product.
Wow.
It's coming from the client.
I see, I hear you.
Actually, government grant is being tested or in universities is beginning to say that is a form of what is it?
Plagiarism.
Yes, plagiarism, and I know our granddaughters use that all the time, and
It's interesting
what that is, it could be for them if they follow through with that. So it's really a touchy issue.
Well, that is interesting, because I would venture to say most professors would appreciate students, and some students using Grammarly, and to the extent of the grammar,
Oh, yeah.
spelling, and all of that, but I get it when it comes to, because you wouldn't even believe half of what you see in some of this work product
Oh,
from
really?
students, yes.
Yeah.
We do have a motion. To return to sub, do I have a second? Okay. A motion and a proper second for this to remain in subcommittee. I like that language, Ashley. Any other discussion of the motion? All right, all those in favor of that motion, please say aye. Aye. Any opposed, say nay. All right, that passes. So we'll take a 10-minute break, and then we'll come back for our new inquiries. Break.
There's a lot discussed here, and I'm sure this is gonna go through subjects, so I'm gonna be fairly brief on the discussion, but basically, this is the who, what, and when of notices to clients when the lawyer leaves the firms, and the when is addressing inquiry number one, and the opinion says that anytime a lawyer leaves the firm, clients affected by the lawyer's departure have to be notified. The who is discussed in inquiries number 2 and 3. Inquiry number 2 discusses which clients need to be informed of the lawyer's departure, and the opinion provides that any affected client has to be informed, and it defines affected clients as current clients with whom the departing lawyer has a personal professional relationship or with whom the lawyer has had significant client contact. And the opinion states that if there is some doubt, that the lawyer and the law firm should err on the side of caution and provide notice to that client. Inquiry number 3 addresses the second who, and that is who should send the notice. The opinion provides that both the departing lawyer and the firm have a duty to give the affected client's notice, and that the preferred method is a joint letter agreed upon by the law firm and the attorney. The opinion goes on to state that if the lawyer and law firm can't agree on a joint notice, that they both have a responsibility to send a notice. The opinion emphasizes that the law firm cannot impede the departing lawyer in his efforts to send out the notice. Specifically, the law firm has to provide the departing lawyer with the client contact information. That's a question that we get quite frequently when lawyers call in. The opinion goes on to state that even if a joint letter is agreed upon and sent out, both the departing lawyer and the law firm have the right to individually contact the clients. Inquiries number 4 and 5 address when the notices should be sent. Inquiry number 4 specifically asks whether the departing lawyer can contact his clients before he lets the law firm know that he's leaving. The opinion states that there's no rule addressing, no specific rule stating what the lawyer can do, but the opinion states the lawyer has a duty to protect the client's best interests, and notes that cooperation between the law firm and the departing lawyer is in the best interest of the client if they cooperate during the transition. And the opinion concludes, therefore, that the departing lawyer should inform the law firm before informing the clients, unless the departing lawyer reasonably believes that would not be in the best interest of the client. Inquiry number 5 addresses the general timing of the notice to the affected clients, and states that the client should be notified sufficiently in advance of the lawyer's departure to give the client time to consider his options and decide who he wants to continue his representation. Inquiry number 6 is the what, as in what needs to be included in the notice. The opinion states clients must be given the 3 options I think everybody's familiar with: stay with the firm, go with the departing lawyer, or get completely new counsel. The opinion points out that the notice does not have to include an option that is not available. For example, if somebody's becoming a judge, he can't handle that representation, so that option does not have to be included. It also points out that the law firm and the departing lawyer have to consider whether they would be able to handle the representation after the departing lawyer leaves. They have to make sure that the law firm has to make sure they have somebody at the firm that would be able to handle the matter, and the departing lawyer has to make sure that he would have the resources to handle the matter. If one of them decides they can't, that option does not need to be included in the notice. The notice needs to include information about the status of the case, an accounting of any fees owed or fees held in trust, and instructions on how to indicate their choice, and the time limit is suggested to be included. If the client's leaving the firm, the notice needs to provide instructions for the client to let the firm know if the client wants to obtain his file or have that transferred to a new lawyer, and the same thing with any funds left in the trust account if the client wants the funds returned to him or transferred to his new lawyer. Inquiry number 6 also addresses a situation where the departing lawyer may have some mental impairment, or perhaps is being investigated for some type of serious ethical violation like embezzlement. Generally, the lawyer is not, there should be no disparagement between the lawyer and the law firm. If there is information that the client needs to know when making a choice, that information should be included as long as it's truthful and factually based. And we talked about that a little bit in an earlier ethics opinion of 2013 FDOA. Inquiry number 7 reiterates that the departing lawyer is entitled to the contact information of his current clients, and inquiry number 8 states that the departing lawyer is entitled to a list of his former clients when that information is necessary to provide conflict checks, and that is also an exception in 1.6. 1.6b talks about providing confidential client information in which to provide conflict checks. And that's the who, what, when, where, how, why of Mr. Savage.
All right. Mr. Lynch. We have the,
Who's that?
You're the chairman.
that's all I'm glad we do.
I think the practice of having both the attorney and the law firm co-sign the letter is great. I think in most instances that I've seen, that's been something that's been achieved. I think it kind of levels the playing field so that the dialogue between the client, the lawyer who's departing, and the law firm is consistent. So that was a great point, and I hope that that's something that you're finding in practice, because it really is best practice.
Any other persons from the subcommittee? Yes.
I'm really happy that Warren proposed this question because it's come up a number of times in the past 13 years in my firm, either as, mostly as the firm managing partner. So I feel good that we've done this nicely, but it's really important to have it set out. I think I've actually called the bar to make sure that we've done things correctly. So to have this in detail is really important, especially for the people leading or the firm, whose place they're living. So I think it's good that you took each item very specifically.
And I apologize because I said subcommittee and we have not sent this to subcommittee.
That's okay.
That's why you were giving me that. Yes, ma'am.
I was just going to point out that, to Craig's point, yes, it's obviously preferred that the letter be signed by both, but the questions I get, and I'm sure that you get mostly, are where the firm and the lawyer, it's a divorce, it's a bitter divorce, and they hate each other, and they don't trust each other, and to have this as a backstop to send it in and say, look, remember clients come first, number one, and I don't care how much you hate each other, you need to follow all these steps and do everything correctly. The other thing I'd like the subcommittee to take part, I'm glad Craig's on it. A question I get a lot is, when is the notice required for lawyers that are working on a file that are kind of tangentially, they might have done some work on it, might have even talked to the client on the phone a couple of times to get some discovery responses, but they haven't made an appearance for them in the case, and they are not, they're one step up from a paralegal's work level of stuff. They've done some research memos in the file. I think we do address that some here, but I would like there to be, the responsible attorneys. Who is it? A third-year lawyer working at Parker Poe, probably if they leave to go somewhere else and y'all represent Coca-Cola, you're not going to send a letter to Coca-Cola and say, you have the option of staying with Parker Poe. We can flesh that out some in that committee, that'd be great.
I just want to reiterate what Warren said on a grand scale than Coca-Cola, but even in a smaller family law practice where the client signs a contract with a partner, right? That's sort of the primary attorney on the case. but an associate attorney is assigned to the case and is doing a lot of the legwork. So they have a lot of client interaction, but it's basically under the supervision or the umbrella of the partner or the primary attorney on the case. So that, like, it's kind of, that part of the opinion, it seems to me, is a continuum, and if there's any way to like flesh that out or give more examples that would make that clear, where that then makes you have an obligation to let the client know that this associate attorney who was working on the case is.
And then, sort of also to that point there are firms where the supervising attorney doesn't do anything. They sign off right there and they assign it to some associate who runs it, is going to try it, got everything on it. And, you know, obviously that's a different situation, but it's hard to, that's where the original, yeah, I won't get into the names, but that's where lawyers get in trouble and fight about that. Oh, I don't need to tell them.
So I'm here to add some examples to that part of opinion 2. So the opinion references an old ethics opinion, RPC 200, as well as an ABA opinion that says that basically the clients who are affected by a lawyer's departure are those with whom the lawyer has this personal professional relationship or significant client contact. I think it was intentionally kind of described but vague to allow the flexibility for what is and is not appropriate. It might be difficult drawing a specific line, but maybe just having examples would be helpful. Okay. All right.
Cool. Yes, sir. Hey.
Not that I have any experience, as all of you know, about ever leaving law firm.
Leave Alan and Jeff.
It was surprising. Opinion 4 was surprising to me. Opinion 4 was surprising to me that the departed lawyer could let his clients know that he was leaving before he left the law firm. As a personal side, I certainly wish I had known that. I wasn't staff for some of my partners. I do think there are, and I realize we're not in the business of opining on the legal implications of that.
Right.
But I don't know whether it's appropriate to say something about that because certainly appropriate corporate opportunities are something that should at least be. I would think people would be alert to that. At the same time,
that's a good idea. There's nothing in the rules that say, and outside of the rules, but I thought I kind of went far in saying that you do have a duty to tell your client first, unless you can show that it's not the best interest. I didn't see that anywhere, but that's what I tied it to what was in the best interest of the client.
But I think this makes perfect sense because, as you say, it also helps facilitate a little bit, and also we have that opinion from years ago that if I was in negotiation with Parker Poe, we got litigation going on. We have to at some point we have to tell if we're on opposite sides of litigation. We have to tell the client that I'm thinking about moving to the law firm that is opposing him. So the rules certainly anticipate that there will be knowledge of that by the client before you jump ship. But I just think maybe it may not be appropriate to say anything about that, but there are.
No, I think it's a good idea to talk about somewhere in here that there's other
considerations.
Other concerns. I thought I had that somewhere, but I probably did not. And thank you for pointing out.
I just echo David's point about I think a lot of it depends on and maybe it's also Nancy's point, who's the main lawyer on the case. I have left for a couple of firms, and sometimes I've left with my cases that my client, who I brought in, real clear what's going to happen with those, but we still send a letter. And sometimes I've worked on somebody else's cases, and we're real clear that kind of stays where it is. Or you still send the letter, but so that they can mark the thing, but it's clear what's going to happen before you send a letter. Does that make any sense? You communicate it to the client,
I mean, the issue is whether you have to send a letter. I mean,
I think you definitely have to send it if it's if you're taking well, I guess, yeah.
it gets complicated,
Yeah.
and I think Nicole and I often say, if you ask the client who their lawyer is, who would they say?
Right.
And if they say the departing lawyer, well, definitely they need
Yes,
to know.
Yeah. Well, I was always I was clear what clients were coming with me before I even sent the letter, because I knew what the situation was, and I think departing lawyers generally know that. If you know if it's your client versus it's the firm's client or another lawyer's client.
I think it can be difficult, which is why I added the statement that if you're not sure, send it, just send it.
I think there's obviously malpractice implications too, to not sending a letter to inform people that an associate who used to work for you, work on a case, no longer works for them.
Works for opposing counsel.
Works for opposing counsel.
Happens all the time in family
Works
law.
somewhere else, so if they
All
call
the
you up,
time.
don't talk to them.
I think we talked about the conflict, you have to look out for conflicts. There's a lot in
Yeah,
that
there's a
opinion,
lot.
and I could have talked about it.
I appreciate y'all.
So I would think that you all may encounter, end up having some discussions about fees too. And I know it was some talking here about the client's entrusted property, which would include fees. But I think that's where, because I think that's where a lot of the negativity between the firm and the departing lawyer, because the departing lawyer, if they're taking the client, they're expecting to take the fee with them, in a lot of instances, so just throwing that out.
I agree, that's where they go.
I think in general, we don't, the bar doesn't get involved in fee disputes between lawyers and the law.
That's where, yeah.
No, I agree with that, but I just know that this might be, still need to be part of the discussion. Yes, ma'am.
Well, I had a question or concern more about number 6, in informing the client about mental capacity issues. I think if there's an investigation, then it's clear, but you might have a lawyer that you're releasing from the firm because of a substance abuse problem. And I'm not sure how best to handle that, and I don't feel like when you're talking about mental capacity issues and then you balance it with, but don't disparage, and you don't necessarily want the person who's leaving to fail, you want them to get help. What duty do you have to your client? I don't think that this opinion really fleshes that out.
We have an entire opinion on that, and I cite to it. I mean, the question is this information that the client would want to know to make an informed decision? And I mean, if they're, it's a very touchy situation.
It is, I mean,
But you don't want, you don't want a client to go off with a lawyer that you know is not in any position to represent them.
Yeah, if it
Based on what you've observed while they're there. And that's not fair to the client that's going to go off.
But it's a really delicate, I mean, you can't necessarily make accusations about, we're letting this person go because they've been to rehabilitation twice and back there again. I mean, you can't say because of substance abuse concerns, really. I mean, I think that borders on disparagement. So having some guidance on what language might be appropriate would be helpful.
Okay.
Right. And also mental capacity, like, if they're not able to meet the needs of the client.
Right, they have dementia, and they have dementia, and they're not in the place where they're admitting that they have dementia. It's just not, I mean, you have to think about the client. But yes, it's very, very, very
It's very delicate, and so if there is some wording that can be used to handle that situation, I think that the lawyers who are the employers are, that would be very helpful.
So do I hear a motion to send this to subcommittee?
Motion.
All right, second.
Second.
All right, any further discussion? All those in favor of sending this inquiry to subcommittee, please say aye. Aye. Any opposed? Nay. If you see your name in parentheses, we would love for you to agree. And volunteer.
Learn all about this subcommittee today.
I already put you on it.
I do have a question. That is, you're attaching a unilateral letter to the client from the departing attorney.
So that's from our materials. I was just giving them as an example of when we're trying to answer these questions, here are the resources I go to, and we have one letter. That's not special, it's nothing other than it's something we provide some folks, we can kind of go by for the mutual letter, because presumably we can mutually agree to something. So
If there's that, thank you.
All right, next new inquiry, the code and criminal discovery in district court. That's you too, Susan.
That's me too. So this inquiry involves a criminal case in district court, and the defendant is facing a Class H felony drug charge, and the DA offers the defendant a deal. And the deal is that if the defendant pleads guilty to a Class I felony, the DA will suggest probation. The defendant doesn't want to plead to a felony. He wants to pursue a misdemeanor offer, and his defense counsel sends the DA a discovery request. Because there's no legal right to discovery in district criminal cases, the DA responds and says, well, if you want the discovery, I'm going to withdraw the plea offer, and I'm going to seek conviction on the Class H felony, and I'm going to seek the maximum punishment. And the issue is whether it's ethical for the DA to make the offer, and if it's ethical for the defense attorney to participate in the plea offer presented to his client. The first inquiry addresses the DA's professional responsibility, whether it's permissible under the rules of professional conduct for the DA to make the conditional plea offer. The opinion concludes that the DA may make this offer as long as the DA is confident that he has complied with his duties that are set out in Rule 3.8. And specifically, we're talking about the rule where it says that the prosecutor must refrain from prosecuting a charge that he knows is not supported by probable cause. And the rule also requires the prosecutor to provide defense counsel with any evidence that tends to negate or mitigate the defendant's guilt, Brady material. And this requirement still applies in district court. The opinion concludes that if the DA has determined that the charge is supported by probable cause and has given defense counsel any exculpatory evidence, the DA is acting within his discretion in presenting the conditional plea offer. The second inquiry addresses the defense lawyer's professional responsibilities, and the opinion states that the defense counsel can participate in the plea offer if defense counsel sufficiently explains the conditions of the plea to his client, including the risk that there may be some exculpatory evidence in the undisclosed discovery. The opinion states that the defense counsel can presume that the DA is acting in accordance with his ethical duties under 3.8. The defense counsel should explain those duties to the client. The opinion states that the defense counsel may also rely on the defendant's own evaluation of his conduct as it relates to the case. And the opinion concludes that after explaining the conditional plea offer, defense counsel should follow the client's directive as to whether or not to accept the plea. And we have been getting this question very regularly all of a sudden.
Yeah.
Really?
Yeah, over the past from 12 to 18 months, all over the state.
Really?
Yeah.
So we have some, if this goes to subcommittee, proposed subcommittee members, your name is in parentheses, would you like to comment? Those folks in the, yes.
Yes, this seems to be one of the holes in chapter 15A. 15A was amended years ago to regulate discovery in Superior Court. but left district court out of that statutory scheme. In Mecklenburg County, Peter Gilbert started doing whole file discovery way before the statutory scheme was set up in Chapter 15A. However, in district court, the discovery has always been informal. That is, if the obligation is on the lawyer to go try to talk to witnesses, talk to the police officers, look at the, the files, look at the documents, and there's no obligation for the prosecutor to engage in any formal discovery methods with defense lawyers or even pro se defendants. So, to me, it's difficult to come to the conclusion of informed consent when you're actually not being informed about what is in the discovery file. However, Suzanne, the way that you have laid out informed consent satisfies, I think, the informed consent. It says as long as the defense lawyer tells the client that these are the limitations, this is what we don't know, but this is what, we're going to have to go ahead if we accept this plea. And it's not unusual for prosecutors to threaten and follow through with enhanced charges with the recommendation that maximum sentences be imposed if the plea agreement is turned down, both in state and federal court. That's a standard practice that prosecutors use, and they use it well. In some jurisdictions, not in North Carolina, lawyers must file Brady motions and Giglio motions before prosecution is under an obligation to reveal exculpatory evidence or impeaching evidence. In North Carolina, we cover that with the rule, under Rule 3.8, which is great. So it really does put an obligation on the prosecution to disclose exculpatory and impeaching evidence. In fact, we have my former law partner is the head of the misdemeanor unit in Mecklenburg County, and she does all the Giglio stuff for district court. She's also buried up to her eyeballs right now with what's known as legacy stuff with Odyssey, and there's just tons of stuff missing that created cases being dismissed. But I emailed her this weekend and asked her to weigh in on this, but she's so busy she just hasn't had a chance. The other thing that two other things that sort of stand out here. Probable cause is such a low standard, even though it's defined as more probable than not. Lots of times prosecutors and law enforcement officers can be very myopic about what is probable cause and ignoring a lot of things. So it's really probable cause is in the eye of the beholder or in the eye of the presenter in front of the magistrate when you go sort of selectively present evidence. But so even though the rules say the prosecutors must make sure that charges are based on probable cause, that really doesn't have much substance behind it. And the other thing, Suzanne, that stands out in this is as long as what you call procedural justice is followed. And that, once again, is kind of squishy to me. I'm not sure exactly what that means. That just means procedural, means you're charged, you're arrested, you're put in jail, you're brought into court, and put in front of the judge, and that's it. But I do think that that kind of gives me a little bit of heartburn, but it's not on us because the legislature is silent on this, and these are the accepted standard practices in district court in all 100 counties. And so the opinion has it right that you've written, and so that's just my insight.
I think we all our initial reaction was like, well, that doesn't seem fair, but then I know Brian talked to some defense attorneys, and then you can take.
Yeah, I talked to some defense lawyers about this, and it was just as Suzanne said, the reaction. I think a lot of us have a reaction. Well, that doesn't seem fair. But I also talked to some ADAs that said, that's something that they're not trying to kind of coerce anybody. It's a matter of efficiency to try to get through the docket. But the defense lawyers in particular, when I said, if there was some ethics opinion that said this was a prohibited practice or an unethical practice, what would you think about that? And their reaction was, and I don't know if our defense lawyers here have a similar reaction, was, I don't want to lose the ability to get the best outcome for my client. And so to the extent that I can just, when that happens, they were describing their practice of talking to the client saying, I don't know what your evidence is. I don't know if the substance that you had actually did test positive for cocaine, that sort of thing.
But you probably know what.
But you know what you have. And if it's true, if these charges can be established by the evidence that's in the prosecutor's possession, this is a good deal for you. And I don't want to lose, as they were saying, I don't want to lose the ability to get the best outcome for my client. And so it was, it was kind of an interesting take in that regard. It focused entirely on their client, and saying, if I can just tell them, I don't know, you know. But if we lose this deal, realize that you might be looking at kind of a worse outcome here. So I think that weighed into some of our conversations.
Well, Brian, I would say this. I would say in the vast majority of cases, the more the state or the federal government does discovery, the worse it gets. And especially when there are specific offense characteristics that elevate, the charge and the penalties. And so lots of times it's actually in the best interest of the defendant to freeze the discovery at that point, especially if there's monetary amounts involved or drug amounts, a conspiracy, for example. So, it kind of cuts both ways.
Right.
I think Eddie certainly is with this.
Yes, I think. We'll go with that, and then I'll have.
Well, what I was going to say, before I took the bench, I was an assistant PA. One of the cases I tried is Cornet, which is referenced in the materials. That was a Surrey County case. And as soon as it came out, of course, I was celebrating that we didn't have to give discovery and all this. And it's certainly a useful thing for a prosecutor district court to do when the defense lawyer comes in and says, I want my discovery, I want it now. And it's like, well, I can't give it to you now. Here's Cornet. Shut up. But then as soon as I was so excited about that case, Ricky Bowman, who a lot of you know and respect, and was awarded the Distinguished Service Award, he was our chief district attorney. He came up to me and he said, do you want, as a prosecutor, the burden of deciding what is exculpatory or not? Let's turn it over. You don't need to be the arbiter of what's exculpatory. So that's food for thought, although I know this practice is routine, and there are benefits to it for defense counsel. But I just wanted to throw that out there. Eddie?
No, I think, when I read this inquiry discussion, very difficult because I do think the rules are the rules, and I think the way it's written up is certainly correct. But just someone who practices, especially considering, I think recently the reason why you're seeing a lot of these questions, hearing a lot of these questions, is because the backlog that came with COVID and also anticipated backlog with Odyssey. And so I know from what I've heard, there's been an emphasis on handling Class H and I felonies in district court. And so because of that, you're going to see, you're going to have this more often. And at least to the legislature's point, I think there's a difference between, and everybody recognizes there's a difference between the felony conviction and the misdemeanor conviction. The collateral consequences that come with the felony conviction are much greater than those that come with the misdemeanor conviction. And so that's why, it would make sense in Superior Court that you have to turn over discovery instead of doing that in district court. Also in district court, you have the ability to have de novo review if with the trial and you lose the trial, you can appeal to the Superior Court for de novo review where you don't have that same ability with the felony matter. So now handling these matters, these felonies and felony convictions in district court and not having discovery is very difficult. There are benefits, as Evan says, there are certainly benefits to just taking this plea and getting it over with, and you know what you did, and this is better than the higher felony or the sentence that will come with the higher felony. I will say that it's not all the time not as simple as just you know what you did. You could have had something illegal, but the stop was wrong. The questioning by the officer was wrong. This is a constructive possession argument that we are going to forego here. So it's hard to make these determinations and make these recommendations to clients without having access to the discovery. But as we all know, this is a legislative problem, and I think the way that we have it written up is correct, at least at this point. I thought that by our last meeting we debated for 2 hours, so I'll see what happens in the subcommittee this time.
I agree. I think that the Chief Justice is really pushing H&I District Court on all the districts, and they've made a big push for that. Rockingham and Caswell counties does not have that, getting it, and so I can see where these problems come from. But also there's this idea that by doing H&I court, a lot of these cases will be disposed of in 30 days, right? And sometimes that is to the benefit of the defendant. But there's also other concerns that I think that prosecutors have that sometimes are not being brought up here, which is, okay, if we give you all this discovery, we're going to end up burning the confidential informant. If we're going to do that, then all the consequences are coming along with this. Part of the reason why you're getting this good deal is not that you deserve it, but that we want to protect this witness or not put them through this whole process so that if it goes quicker, they're happy with the end result. But if they have to go through the whole process of full-fledged discovery, and a lot of times the DA's office is not going to have all of the discovery. If you're talking about it's in district court, well, then they're like, well, we can indict this, and then instead of having to come before a district court judge who's upset, like, hey, this case has been in district court for 3 months. Why haven't you disposed of it? Which is obviously a good thing for them to do that. It's just going to go through Superior Court, and then you went through all that trouble. Well, we might as well play for all the marbles, I guess, as opposed to if it's efficient, and I do think in most of the time it is, in order to the benefit of the defendant, actually. So.
Ms. Cleveland, you want to make any comments?
These folks know more about it than I do. I didn't do a whole lot of this in practice, but in the little time I've been there, we've got a couple days a week that we do what is ironically titled PC court, where there's not been a PC hearing in 25 years. But what we do is H&I pleas, and we roll through them. So we've all memorized the transcript because we are burning through these things. It keeps them from going to indictment. I don't know one DA versus another how trustworthy they are about whether they're telling you what they actually know. But a lot of what we see is they're holding over their head not but indictment as habitual felons. And that one after another, that's what the thumb screw is. If you go forward with this, man, you're going away. So that we just roll them out.
Yes, ma'am.
I understand that it is more of a legislative issue, but we have H&I court in our district, and I am just now realizing how lucky I am because it's part of our local rules that our chief judge says defense has to get discovery before we'll proceed with a felony plea in district court. And I thought that every district that had H&I court operated that way, because I don't know, that is such an untenable position for the attorney to advise. I mean, if it's say a buy, where they've got a controlled buy, you don't know who the confidential informant is when you're trying to advise your client on whether or not to take a plea. I mean, I don't think that works, and I know that that's not this committee's responsibility, but I feel like in every discovery packet, there is some exculpatory information. Now, again, I don't want the prosecutor to be the arbiter of what is exculpatory and what is not, whether it's on purpose or an error. I mean, there are so many different factors in going into a felony plea that I feel like it wasn't contemplated when they're talking about the discovery requirements for district court. And I just really hope this does go to subcommittee, and I hope that there's a defense lawyer who practices in H&I court on it, because I think that's really important to bring that perspective. Because if you're tabling it with I'll do it, that's fine. But if you're talking about efficiency, I mean, you can be efficient, we might as well just send everybody to jail. Like, I don't think that works. Yeah, that's the most efficient. Yeah, dismiss everything or convict everybody. Done. Why are we even in court?
So,
you know, I think
was that your motion? So it was a motion to send to subcommittee and put you on.
We can, that's, yeah, I think we can. I know.
Judge Ramey and I were both prosecutors and have some experience with it. Mark Herrick, I think it's only reasons.
Do you want to be on it? Or should I put the other?
Well, that was, I will confess, I was thinking of putting Judge Ramey, given his most recent occupation, but since this is his first ethics committee meeting, I don't want to slip through.
All right, so I got a motion to send to the subcommittee. Do I have a second? Second. Okay, good. Any more discussion on that motion? Well, any discussion on the motion, all other discussion was not on the motion. Okay. All those in favor of sending this inquiry to the subcommittee, please say aye. Aye. Any opposed, say no. All right, so we got to go to subcommittee, we got some big subcommittee members. Our last new inquiry. Negotiating licensing reporting capabilities or media.
That's me. This is the inquiry of the Dispute Resolution Commission. We actually received two separate inquiries.
Yes.
About the lawyers. Okay, so they asked us to write an opinion. The first inquiry was about.
Sorry, the very first opinion.
The
right.
lawyers.
No, that came from, I guess, a number of conversations that I've had about this question of whether or not a lawyer can put in a settlement agreement that the lawyers will not report each other to the state bar, that no party will report the lawyers involved to the state bar. I've had a number of calls or just conversations with folks from, I'll say, across the state that seem to be unaware that there are existing ethics opinions that say you can't do that. So,
and then we got an inquiry from the Dispute Resolution Commission about whether lawyers serving as a mediator can participate in the parties and their lawyers negotiating away the filing of agreements. So we combined those instead of writing two separate inquiries. So the first inquiry involves lawyer A and lawyer B or opposing counsel in a matter. They are trying to resolve the dispute between their clients by mediation. The interaction between the parties and the lawyers have been contentious, including people are making allegations of misconduct by the lawyers involved in the matter. So the parties decide to settle the matter prior to trial and instruct their respective lawyers to negotiate a settlement, but that settlement will also include that neither party and neither lawyer will file a grievance complaint against any of the lawyers involved in the matter with the state bar. So the question is that allowed? We already have an ethics opinion, RPC 84, that says no, it is not allowed. The opinion goes through the analysis of explaining that the legal profession is a self-regulating profession, And in order to do that, we have to be able to investigate lawyers who are accused of misconduct under the rules of professional conduct. And in term, in a settlement agreement that would allow the lawyers of the parties to agree that they won't file agreements, undermines and threatens our legal profession's ability to carry out our critically important responsibility of privilege or self-regulation. So the opinion provides that it is a violation of Rule 8.4D, which is the misconduct rule that says that lawyers cannot engage in conduct that would be prejudicial to the administration of justice, and cites RPC 84, which is an older ethics opinion that we routinely advise lawyers when they contact us for informal advice and remind lawyers that they cannot negotiate away the filing of agreements. If a lawyer is aware of misconduct, then the lawyer has a duty to report that to the state bar or to a court having jurisdiction. Inquiry number 2 is where we get into the lawyer serving as a mediator. So we have a lawyer mediator who is helping parties and their counsel resolve a dispute. During the mediation, one of the participating lawyer proposes that a party shall not file a grievance complaint against any lawyer involved in the case. And the term is to be included in the mediated settlement agreement. So the question is the lawyer mediator in violation of the rules of professional conduct if they act as a scribe and prepare this mediated settlement agreement that includes a term that the parties will not file a grievance against one of the lawyers or any of the lawyers? And the answer to the question is yes. As stated in the preamble to the rules, lawyers serving as a third-party neutral are subject to the rules of professional conduct, which means that they cannot, under Rule 8.4A, which is another misconduct rule that says that you cannot do through another what you cannot do yourself. So you can't pass on or let go of your professional obligation by asking somebody else to do it. So the mediator, because he is a lawyer, he cannot assist the parties with a settlement term that includes not reporting one of the lawyers of the state bar. Inquiry number 3, based on the same facts as inquiry number 2, except that one of the lawyers involved in the mediation drafted the agreement. The mediator is then given the agreement, so it is in writing, and the question is the lawyer mediator in violation of the rules taking the term that was written by one of the lawyers, prohibited the filing of agreements with the state bar in writing back and forth between the parties to while they work through a negotiation. And the opinion provides yes, it is a full violation, and it cites the opinion number 1, which says that lawyers cannot negotiate away the filing of agreements, and then number 2 that says that the lawyer mediator is going to be responsible and can't assist the parties with negotiating away the filing of agreements. Inquiry number 4, is the outcome different if the mediator verbally transmits the settlement term to the parties? So in opinion number 2, it was a writing, and is that a violation? And so the opinion provides it doesn't matter. So whether the lawyer mediator is transmitting the information verbally or in writing, it is still a violation of Rule 8.4D, conduct prejudicial to the administration of justice, and 8.4A, misconduct you cannot do through another what you cannot do yourself. Inquiry number 5, the parties don't reach a settlement at the mediation, but they discuss this term with the mediator about not filing a grievance. Later, after the mediation has concluded, the lawyers get together, they resolve the matter, they draft a settlement agreement, including the term that nobody is going to report at one of the lawyers or both the lawyers to the state bar with a grievance. And the question is the mediator in violation of the rules by knowing that the term prohibiting the filing of a grievance was discussed at the mediation? And if so, does the mediator have a duty to warn the lawyers against the provision and or report the lawyers to the state bar? So the opinion basically provides that if the lawyer mediator is unaware of the inclusion of the prohibited term in the final written agreement, that the lawyer does not have a duty under Rule 8.3, which is our reporting rule that requires a lawyer to report another lawyer if the second lawyer's conduct raises a substantial question as to the lawyer's honesty, trustworthiness, and fitness to be a lawyer. The opinion goes on to state that if the lawyer mediator informs the other lawyers that they can't include the term, so while the negotiation is going on, and the mediator says, you guys can't include this term in the settlement agreement, it violates the rules, then the mediator has not participated in helping the parties agree to such a term, and there would be no violation against the mediator. Inquiry number 6 discusses the standards of professional conduct for mediators. In particular, standard number 6 states, a mediator shall limit himself or herself solely to the role of mediator and shall not give legal or other professional advice during the mediation. The standard also states that a mediator may provide information that the mediator is qualified by training or experience to provide, but only if the mediator can do so consistent with these standards. So again, no providing of legal advice or other professional advice. A mediator may respond to a party's request for the mediator's opinion on the merits of the case or on the suitability of settlement proposals. So the question is, assuming that the facts in the previous inquiries constitute a violation of the rules of professional conduct, and they do, but the lawyer mediator is unaware of the rules or the ethics opinions that prohibit lawyers from negotiating away the filing of agreements, is the lawyer mediator subject to the rules? And the answer is yes. The opinion explains that all lawyers, whether you're serving in a fiduciary role or in a legal capacity in terms of representing a client, if you're an advocate, you all have a duty, or we all have a duty, to have a basic knowledge and understanding of what the rules of professional conduct require of us. And then concludes that ignorance of the rule is no excuse. So even though the standard says that the mediator is not supposed to give any advice, basically, once a lawyer, always a lawyer. You wear your lawyer hat all the time, and you have an obligation to follow the rules of professional conduct.
All right, that's all right. Thank you. The folks that are in room C's on your agenda, if you would like to weigh in as a proposed subcommittee member. Yes, sir.
I don't want to complicate it. I thought Nicole got it exactly right, and I don't think it needs to go to subcommittee. I think it's ready to go. It's just something you can't do, and I think it's pretty clear, and I think she did capture it. So I would say we publish it. I think that's the right thing to do, or not. Since we're not, I don't think it needs to go to subcommittee, so I think it's ready for publication. That would be my motion.
Second.
Okay.
There was a motion and a
There's
second.
a motion and a second.
Discussion.
Discussion?
Yes.
I think she got it exactly right to the extent that it addresses the question that come up with conflicts at mediation. There's all three lawyers, we're just talking about the mediator here, but all three lawyers in this case are doing stuff that aren't discussed here. The threat of reporting somebody as part of leverage in a case, grievance in and of itself, I think unless you intend to follow through on that threat, is potentially unethical. The lawyer who is accused of having a conflict during the mediation, should the mediation, if it is material, should the mediation even go forward? Who's responsible? What if the mediator recognizes that the conflict is so that the lawyer that's sitting there with his client, he knows that lawyer is not telling the client what he knows that lawyer knows about the case because of his own conflict. There are all kinds of implications that come up a lot in mediations. I've talked to many mediators who have been sitting there very alarmed by what is, they hear an attorney telling their client, knowing what's going on. I don't know if we want, just because this came from DRC and it seems to be in response to a pretty specific scenario here that was alarming. Thank God none of these are lawyers mutual insurance. But it is something that conflicts that come up at mediation is something that, and how to go forward with those negotiations. So whether we do this or not is a question to consider in the future, whether through this opinion or some future inquiry.
Yes, sir. Comments on?
One other question I've got, I do mediations, and unfortunately, sometimes curiosity kills the cat. They get settled in this last scenario. You don't know what's happened with it after the fact. But then, curiosity being what it is, I call and I say, did y'all get it settled? Oh yes, and these are the terms. And then it's revealed that one of those is we're not going to report anything to the grievance. Now, as the mediator, do I suddenly am impressed with an obligation now to report this to the law? I didn't do it, wasn't party to it there, but now I have knowledge of it. I don't know whether this addresses that, maybe I missed it.
It kind of indirectly addresses it, because it says if a lawyer doesn't know, then they don't have the duty. And I guess that would be maybe a question of whether we would need to get into the analysis of, does a lawyer engaging in or agreeing to this term rise to the level that triggers the reporting requirement? Because remember, triggering the reporting requirement is a pretty high standard. It's not just, you didn't call your client for 6 months, I have a duty to report you. No, it's got to be significant misconduct that reflects adversely on the lawyer's trustworthiness. Whether this amounts to that, I don't know if we've ever advised on that particular thing. I feel like, that might be something for discussion.
To me, if somebody told you you're about to do something unethical, and you go ahead and do something unethical, that rises. That's different than just.
He's gonna say there's no coverage.
Yes, sir. I know we're running up against our 1 o'clock time, but I want to make sure.
12 o'clock.
I mean, 12 o'clock. Yes. That's what I mean.
Is well done and is well said. I agree with everything in that opinion. DRC has got their own issues of confidentiality, and the current rules have carve-outs for, when a mediator can reveal information. They're fairly narrow, but I don't think they have anything that addresses this specifically. And I would suspect this has come up, and they need to define an answer. Our opinion will give them what the information they need to then probably modify their rule accordingly.
Yes, sir.
I mean, I thought the last sentence or two where Nicole says the rules apply to mediators, and you have to make a judgment call as to whether this is something you have to report out, which is something we all do on a case-by-case basis on lots of stuff. I mean, I think we could do order lots of other scenarios onto this, but I think this was fine, and if we want to craft another opinion, that's fine too, but I thought this got it right, and that this is what they asked, and we told them. If they want to ask something else. But I do think that put the capstone to it, Nicole, by saying you're still a lawyer, and if you have to judge what you have to judge on that basis.
Yes, sir.
And I agree with David. Let's publish it, get it out there. If we get enough comment that makes us want to expand it, then we can do that. But if not, let's just get it out there.
All right, anybody else have any discussion before I call the question? All right, we have a motion to publish and a second to publish. All those in favor of publishing this opinion as written, please say aye.
Aye.
Any opposed, say nay. It will be published. Thank you. All right. We have no ethics about it. We have no ethics. Okay. We have completed the entire business, so I don't think we need a motion to adjourn. Thank you all. For your 12 o'clock.
Because we're looking like that.